Good morning. I hope you all hear me well and see me well. This is the webinar on the European Arrest Warrant and Fundamental Rights. I'm sure that we are all very sorry that we cannot be in Warsaw today and tomorrow, but this is how it is. So this is the online edition of the series of seminars that we are implementing together with participating judicial schools under the grant provided by the DG Justice of the European Commission. My name is Petra Enei. I'm Senior Lecturer at IPA, and it is my pleasure to welcome you today here. Let me again stress that I very much hope that all technical issues have been ironed out. Our good colleague Christian Lamesh, who has been in touch with you, is happy to help you throughout the seminar should you encounter any IT-related issues. We have also technical support from the platform providers, so I very much hope that we will be at the mercy of the IT today. So let us continue. You have seen the program. What's ahead of us is that first we will have a general introduction to how fundamental rights are protected in the EU on the one hand, and what are those topics where fundamental rights protection is absolutely pertinent in the context of the European Arrest Warrant. So this will be a little crash course on the structure of protection and main issues. And then throughout the 2 days, we are going to map out those in detail. In this context, you will first hear a presentation regarding the procedural rights in the context of the European Arrest Warrant. That will be followed upon with the issue of detention conditions, which we see absolutely pertinent in the execution of the European Arrest Warrant. After lunch, we will be having a case study, and in the afternoon, we are going to discuss the interrelationship between the European Arrest Warrant and extradition requests in the context of mostly fundamental rights, but also EU citizenship. And tomorrow we will turn our attention to the in absentia trials and other selected programs with regard to the European Arrest Warrant. So having gone through the introduction, let me share my screen and concentrate on the first topic, that is fundamental rights protection within the EU and in the context of the European Arrest Warrant. So I hope I'm stating the obvious, but if not, let me just highlight that fundamental rights protection in the EU emerged basically at the end of the 60s, early 70s, basically on the very direct demand of the German Constitutional Court. The Court of Justice in Luxembourg identified the so-called general principles of EU law, and this new source of EU law was the vehicle of identifying and then protecting fundamental rights within the EU context. So this is what I would like to emphasize, is that it was a very novel, almost revolutionary step from the side of the Luxembourg court to basically create this new source of then community law. Now we call it EU law, based on the constitutional traditions of the member states and the international human rights treaties corroborated by the member states. Of course, in this exercise, the European Convention on Human Rights has a special significance. The Luxembourg Court has identified the convention to have of a special relevance from which it draws inspiration. General principles of EU law are largely unwritten sources. So basically from then on, we have the case law of the court in which basically the court one by one identifies specific EU law protected fundamental rights. The big change, however, of course, comes with the adoption of the EU Charter of Fundamental Rights, which have been proclaimed in 2000, but finally entered into force with the Lisbon Treaty in 2009. Now, what are the specific features of the Charter? This is the EU's own Charter of Fundamental Rights. It's a fundamental rights catalogue, and it is not at all identical to the European Convention for the Protection of Human Rights. So basically, the big difference between the Charter and the ECHR is that the Charter is a much more modern text on the one hand. On the other hand, it's full with social rights and second and third generation rights. And obviously, the ECHR concentrates on civil and political rights. Apart from this, the ECHR remains absolutely significant for us because both the Charter and the Lisbon Treaty's text underline that the Charter is to be interpreted with a view to the ECHR on the one hand. On the other hand, the ECHR serves as the minimum level of protection when it comes to fundamental rights protection in the EU. So if you want to imagine it, if we would like to visualize this, we should imagine that basically the safety net, the absolute minimum level of protection, is defined by the ECHR, and the EU has only one choice, basically, to go further, to go beyond, and ensure a higher level of protection. If we look at the Charter, which is today the prime reference point in fundamental rights protection, we see that the Charter does look differently than the Convention. It doesn't follow the typical structuring of international covenant when it comes to rights. So it's organized around titles, and for our purposes, besides the dignity and freedom titles, the most important ones, one is the title on justice, which identifies right to effective remedy, presumption of innocence, legality and proportionality in criminal offenses, and fair trial rights. So these are the Charter-based rights, which are today hard and written law. Let me add, however, that with the entry into force of the Charter, general principles of EU law were not put out of effect. So the general principles are still there. They are now recognized at the treaty level as a general reference, but it is still possible for the Luxembourg court that in the context of the general principles of EU law, identify additional rights which are not mentioned in the Charter. So my point in this little introduction would be to emphasize that no matter that the Charter has entered into force, and no matter that we have now a written catalogue of fundamental rights within EU law that animates all the dealings of EU institutions and member states when they apply EU law, that doesn't put out of effect and does not empty out the general principles of law source of EU law, which will always be there and will continuously provide a well for the Luxembourg court to identify additional rights which cannot be found verbatim in the Charter. So this is an important thing to understand, that there is still this duality with regard to fundamental rights protection. Let me also highlight a point that is interesting. that the charter makes distinction between rights, freedoms, and principles. We will be talking about rights and freedoms mostly, but in your career, it may occur that you come across in a provision to be found in the charter, which is structured as a principle, and that is basically a principle, an aid to interpret and apply EU law, but it's not open to derive rights from it. So there is a distinction between rights, freedoms on the one hand, and principles on the other hand, which do not generate subjective rights, so to say. So if we look at the Charter's final provisions, which talk about the scope and field of application of the Charter, there are a couple of items I would like to highlight which basically govern the application of the Charter. So as I already mentioned, the Charter is to be applied and is applicable in all situations where EU institutions take measures. But for our purposes, the most important aspect is that the Charter is to be applied to member states when they are implementing EU law. Now, this has been a heavily litigated expression and usage of competence. Now, the Charter's horizontal provisions also tell us that Charter rights, the interpretation of Charter rights must correspond to ECHR, the interpretation of the respective ECHR right. So basically, the two catalog of fundamental rights pulled very much close to each other, and cross-references are maintained. There is a provision to ensure that member states' constitutional traditions and the such constitutional traditions are relevant for the interpretation of the Charter and remain fully recognized. As I said, there is a non-regression clause in the other sense that nothing in the Charter can be interpreted in a way that would limit rights to be found in the Charter. So this is the very briefly the fundamental rights context in which the European Arrest Warrant operates. So this is general. So far, this was general EU law. Now, if we look at the European Arrest Warrant itself and the text, what we see that the European Arrest Warrant is not especially seasoned with fundamental rights related provisions, and basically this, let's put it like that, oversight is the reason for this sort of oversight is that when the European Arrest Warrant was adopted in 2003, this was basically the very first instrument of mutual recognition and the taking off of EU criminal law, and an array of issues that emerged in the last, let's say, almost 20 years were simply not foreseen, or their relevance was not foreseen at the time. So the idea when the European Arrest Warrant was adopted is that the solid jurisprudence of the Strasbourg Court and the European Convention of Human Rights will be sufficient so that member states can enter into the intensified cooperation that is required by the European Arrest Warrant. Hence, the European Arrest Warrant itself is not rich in fundamental rights references. But one reference is to be found in the preamble of the European Arrest Warrant, which talks about the mutual trust between member states and talks about the possibility that should the member states gravely violate fundamental values of the European Union, then the European Arrest Warrant traffic should be suspended. At the time of writing, nobody thought that this provision should ever become either contentious or relevant. Today, what we see with the backsliding of certain EU member states, that this so far dormant provision is alive and kicking. Now, the Preamble 12 of the European Arrest Warrant basically makes references to the Charter and basically the justice title of the Charter, and makes a specific non-discrimination clause. But we are talking about preambles, which are the non-normative parts of the individual rights cannot be derived from these parts of the European Arrest Warrant, because these provisions are to be found in the preamble and not in the enacting provisions. The only provisions which basically define rights that for individuals to be derived are found in Article 1, Paragraph 3, where there is a general declaration that the European Arrest Warrant shall not the respect of fundamental protection within the EU. And we see two other references in the European Arrest Warrant which relate to the rights of the requested person, about getting information about surrender, etc., and the hearing of that person. So this was the overture from the side of the European Arrest Warrant, and let's see what happened in practice. Basically, initially, the Luxembourg court was quite reluctant to fundamental rights in the interpretation of the European Arrest Warrant, basically arguing that arguing for the integrity of the text and the untouchable idea of mutual trust and mutual recognition. So the first cases were basically directly or indirectly challenges were made towards the European Arrest Warrant. The court basically adopted a rather deferential approach and especially in the Radu case, pretended as if not hearing the real question and talked about the general fundamental rights embeddedness of the European Arrest Warrant. However, there was a pertinent issue which proved relevant enough that the European Arrest Warrant's text itself had to be changed with regard to in absentia trials, and this is what we are going to study in more detail tomorrow, where we are going to see that how in absentia trials made it difficult to execute European Arrest Warrants and how the 2009 amendment of the European Arrest Warrant was necessary to pave the way how to accommodate procedural guarantee issues with regard to in absentia trials, etc. Having said that, we see in other from other aspects that fundamental rights issues constantly emerged with regard to the application of the European Arrest Warrant, and this was partially due that it has become an instrument which was applied on the wide scale. So the European Arrest Warrant, as we all know, has become too much successful or too successful instrument, and because the number of cases was growing, more and more infant diseases of the European Arrest Warrant was identified. And such issue was that for how long a person can be detained under the European Arrest Warrant while the executing authority assesses the execution of the European Arrest Warrant. That was the question of the Lenigan case. And from then on, we see that fundamental rights related issues knock on the door almost on a yearly basis or very frequently. Court of Justice. What does the detention mean? Whether electronic tagging is detention under the European Arrest Warrant, and according to the interpretation of the according to the interpretation of the Court of Justice or not. Who are the issuing authorities? Whether the issuing authorities, if are not prima facie judicial authorities, what attributes they must have in order to be able to issue European arrest warrants? Whether the European arrest warrants need an underlying national arrest warrant, etc. So these issues were clarified on the go. And of course, the culmination of the fundamental rights exposure of the European arrest warrant is the cases about which you will have a distinct, a separate session today, which basically the big turning point of the Court of Justice of the European Union. And basically making the big leap to fully accommodate the European administration of the European arrest warrant in a fundamental rights context and in the realities of the state of justice of justice systems in the member states. Having said that, it was not only the court that was exposed to the situation that the fundamental rights background and the fundamental rights context of the European arrest warrant needs to be strengthened. The political institutions were as well in ensuring that application and administration of the European Arrest Warrant is supported with a specific legislation, because it was understood that mere reliance on the Strasbourg case law and the ECHR is not sufficient, and the European Arrest Warrant must be backed up, supported, and surrounded with specific EU legislation on the procedural rights of suspected and accused persons, and such rights need to have European and EU level of a harmonization in order to ensure that persons, suspected and accused persons, benefit from the same minimum rights all over Europe on the one hand. On the other hand, issuing and executing authorities can be certain what's happening on the other side, and in order to prevent the situation that the issuing and the executing of the European Arrest Warrants become conditional on specific fundamental rights requirement posed by the respective member states. So basically the EU from 2010 started to adopt one after the other the so-called fundamental rights, procedural rights guarantees legislation, which are all directives and which basically tackle individual procedural rights. So we don't see a big comprehensive one-piece instrument. It's a typical EU piecemeal style of regulation. So basically one directive per procedural right, and this is this series of legislation lasted almost for a decade for the EU, and the last pieces were not a decade, let's say 6 years. The last pieces were adopted in late 2016, and the details of and the relevance of this series of legislation will be highlighted in our next presentation. So, turning the question, what we have seen so far is that how fundamental rights are protected in the EU. What are the main sources, the main vehicles of fundamental rights protection? On one hand, on the other hand, what we sort of considered is that how the European Arrest Warrant makes references to fundamental rights protection, and how that was enriched both by case law and by secondary legislation from the EU. So now I would like to turn the question and give you another kind of viewpoint. What are the pivotal fundamental rights considerations for when a European Arrest Warrant is issued, and what are the pivotal fundamental rights considerations when a European Arrest Warrant is executed? So for the issuing authority, when the issuing authority is about to issue a European Arrest Warrant, proportionality is the first principle that will ensure a fundamental rights minded approach, where basically the hint is to reflect upon whether indeed a European Arrest Warrant need to be issued at all, given the taking into account the seriousness of the offense, the penalty likely imposed, the likelihood of detention of the person, and basically the interests of the victims of the offense. So these are the items that issuing authorities must go through in order to adjudicate properly whether the issuing of the European Arrest Warrant is proportional at all. Today, the EU and the member states themselves devote great attention to the fact that there are other EU instruments out there that can be used instead of issuing a European arrest warrant. So today, to a certain extent, the proportionality reflection also includes the thinking about whether it is another EU instrument to which recourse should be made to. Most importantly, the European Investigation Order, which provides video conferencing, which provides carrying out investigative measures that can easily replace the issuing of a European arrest warrant. Now, for the before issuing a European arrest warrant, the double jeopardy or the nebis in them principle needs to be closely looked at by the issuing judicial authority. In that regard, the European Court of Justice basically developed a very rich case law in identifying what is how the same trial, how the same proceeding, how the same judgment can be defined with regard to the temporal scope of the principle, with regard to the material scope of the principle, who is the same person, what is the final decision, what does a trial resulting in decision mean, what is the material scope with regard to enforcement requirement, and what does the criminal nature requirement mean in the context of EU law. And of course, for issuing authorities, the in absentia nature of the proceeding will be a consideration, and it's very wise to think ahead in order to prevent grounds of refusals, being faced with the grounds of refusal on the basis of in absentia a decision, and basically prevent them with a very clear and concise description of how the in absentia trial was conducted in order to benefit from the exceptions offered by the European Arrest Warrant. And this is something we are going to deal with in a specific presentation today. Now, with regard to fundamental rights considerations, we still find two other items which haven't been mentioned so far, which relate to the fundamental rights of the surrendered person. That is the review of custodial life sentence or lifetime detention orders, whereby a guarantee can be asked by the executing authority from the issuing authority to ensure that the person will have the possibility to have his or her custodial life sentence or lifetime detention order be reviewed in the issuing member states. This is based on the specific case law of the European Court of Human Rights. And the other is the possibility to return residents on the basis of a guarantee provided by the issuing member state to the executing state, so that the executing state can make sure that nationals serve their custodial sentences in their home countries. And this is a way how to ensure privacy, but more so family rights of the suspected and accused person, or at this stage surrendered person. So this is how the quick crash course on quick introduction the fundamental rights embeddedness of the European Arrest Warrant about, and I hope highlight some ideas that we are going to map out today and tomorrow. The intention of this presentation was to basically paint a broad picture, the details of which we are going to touch upon today and tomorrow. So having said that, I would like to open the floor for questions. please step in, asking your questions by pushing the speak panel, or using the chat room function. We are following the chat room, and should you have any question, we are absolutely happy to have them and to discuss them. Thank you very much for your attention.